Plaintiff files a lawsuit. Defendant receives the lawsuit and says, wait a minute, we've seen this claim before. So the defendant files a motion to dismiss based on the Res Judicata Doctrine. And that's what we're going to talk about today. Filing the same claim. Can it be done? And we're going to look at the exceptions. So let's get started. So let's define res judicata. Res means subject matter. Adjudicata means adjudged. So if a case is presented before the court, which has been already decided by another court having the same cause of action or claim, and between the same parties, then the court will dismiss the case and apply res judicata doctrine to preserve the effect of the first judgment. So let's look at the elements of res judicata. In order for res judicata to be applicable, 1, the prior decision was rendered by a court of competent jurisdiction. 2, there was a final judgment on the merits. The lawsuit concerns the same claim or cause of action as that now asserted. 4, the prior action was between the same parties as are in the current action or their privies. So let's look at some exceptions to res judicata. Remember, one of the elements for res judicata to be applicable is the adjudication must have been made on the merits of the case. Well, the flip side of that is when the adjudication is not or was not made on the merit of the case. So let's look at Keeley versus Croft to illustrate non-merit adjudication. So let me give you the backdrop of this story. Keeley was incarcerated in the defendant's institution, and while there, he sustained some injuries. So in May 2013, Keeley filed a 1983 lawsuit against the defendant entity and some individuals for medical negligence. The court dismissed the case. It held it did not have subject matter jurisdiction. In August 2013, Keeley sued again, a 1983 lawsuit again for medical negligence. The case was dismissed. The court held that Keeley failed to meet certain filing requirements. Then again, Keeley sustained another injury. He filed a 1983 lawsuit based on medical negligence. In August 2014, the defendant filed a motion to dismiss. Their argument was that Keeley's May 2013 and August 2013 cases were based on res judicata. The court agreed and dismissed Keeley's June 2014 case, again, finding that it was res judicata based on the May 2013 and August 2013 filings. And by the way, the defendant also asked the court to convert plaintiff's motion to dismiss into a motion for summary judgment. Now, Keeley appealed the case, and the appellate court found that because Keeley's former lawsuits were not adjudicated on the merit, res judicata was not applicable. Now, further activity went on in this case, and you can read it on your own, but I just wanted to review this part to address the res judicata doctrine. The court concluded regarding subject matter jurisdiction that generally a dismissal for lack of subject matter jurisdiction does not operate as an adjudication on the merits, and you can find that on page 4 in the case. Regarding the mandatory filings, the court found that dismissal of the complaint on the ground plaintiff failed to comply with a filing requirement was not a dismissal on the merits. You can find that language on page 5 in the case. Now, let's look at some other exceptions. The former lawsuit was disposed of ex parte. The former lawsuit was dismissed for lack of jurisdiction or improper venue. The adjudication was not made on the merits, as we just saw in Keeley versus Croft regarding subject matter jurisdiction. The former lawsuit was dismissed prematurely. The former lawsuit was for want of cause of action. The former lawsuit was dismissed for non-joinder or misjoinder. It's making sense, isn't it? So it is possible to file the same claim. I am Advocate Lucinda, and we will see you next time. Take care.